Hello, everyone, and welcome to the fourth and final session. I'll just wait a second for the connection to stabilize. And I'll just kindly ask everyone to mute their microphones unless you're speaking for now, so we can try and make sure that we've got a really strong connection. So, welcome, as I said, to the fourth and final session of these webinars for national human rights institutions on the subject of the implementation of judgments of the European Court of Human Rights. The fourth session concerns writing effective Rule 9 submissions, and I'll be very happy just to give you some introductory remarks and set out the agenda for today's session. So we're going to start off with a couple of comments from me just to recap the things that have been said in the training video that was sent to you by Nikos Staropoulos, Head of Division in the Department for the Execution of Judgments. If you haven't seen that video, I do recommend that you watch it. There's some good lessons to be learned there about the effective writing of Rule 9s. So we'll have that. We'll have a bit of an open discussion. Now's the time, I think, really, everyone just to share your comments, and it'd be very interesting to hear from all of you. If you have any questions about this subject matter, please put your questions in the chat straight away as soon as I sort of start talking. That will help us to assess what questions are coming in for us to be able to see and respond to those as well as we can. After the open discussion session, we'll have a bit of more of a presentation from my colleague Agnes with a little bit more information about the implementation monitoring process. In particular, some of the key lessons about when to submit, the timing of submissions, and on a few other details. Then we'll turn to a case exercise. The Public Defender's Office of Georgia has done some really great Rule 9s over a long period of time. They've been working on this issue and engaging with this process for quite a long period. And they'll be talking about their submission that will be made today in the group of Sinsabadze, which concerns torture in Georgia. Then we'll move to a wrap-up session, and finally, concluding remarks from Lina Laikas. So for now, just a little bit, again, to put this in context of what we're working on today. One of the things we've talked about is how NHRIs can address implementation ineffectiveness, so reforms not perhaps working as well as they should. And a key way for that to happen is, of course, engaging with government. But finally, in this session, we're talking about contributing to the Committee of Ministers monitoring process in Strasbourg. It's really important just to put this in context and to say that it's very vital for NHRIs to understand the conversation that's ongoing between the Council of Europe and national governments before they make submissions. So to see all the relevant action plans and action reports that are put in, and to make sure that they put things in at the right time in order to make a contribution to that conversation. Finally, just a few comments from me before we open up the discussion about the most common mistakes that we see when people are writing Rule 9s. And there's four sets of things there. They echo a lot, I think, what Nikos said already in his video presentation, and they're poor evidencing, lack of clear recommendations, poor structure, and bad timing. When it comes to evidencing, sometimes NGOs or NHRIs can make submissions where they say, well, the government hasn't made reforms on X, or the statistics on Y are still a problem, but they don't put a footnote in or a reference to where that information comes from, or perhaps they won't even make a claim that there's evidence at all. They just say blanketly, elections are still fraudulent in the country, or something like that. And that's obviously not sufficient. It's pretty uncommon that we have that problem with NHRIs in comparison to NGOs, because NHRIs obviously tend to be more sophisticated, or not always more sophisticated, but they tend to never be unsophisticated. Let's put it like that. But still, it's an important point to note. Second point I mentioned is a lack of clear recommendations. It's so important to finish off the document, the Rule 9 submissions, with a very clear set of things that you want to say and you want the committee ministers to do. Sometimes people hope that if it's in the text of the document, that the key recommendations or the key actions for the Committee of Ministers will be picked up by the Department for the Execution of Judgments or the Committee of Ministers. But often that's not the case, and it really needs to be set out clearly at the end. And in the example that we'll deal with today, there'll be a good case of that. Structure is also really important. Nikos also mentioned that. It's really key just to have a clear heading for each of the main points that you want to make, again, to make ease of reading. Bad timing, this is something that my colleague Agnes will discuss a little bit more it's not very clear sometimes when it's best to engage the implementation monitoring process, and the timeline can be quite difficult to understand from the outside because that's the nature of the process. But it's really important for NHRIs to understand that, and Agnes will talk a little bit more about that in due course. We're not going to go on to this point quite yet, but instead we're going to open up the discussion to your questions and your comments. So please do go ahead. If anyone would like to come online and make any comments or ask any questions to us, now's the time to do it. You can do so either by just putting your question in the group chat, or indeed by raising your hand. But if there's no one coming in right now, what I might do is just bring in Leonie from the Dutch National Human Rights Institution. I know that Leonie's kindly said that she'll make a short contribution about her experience of engaging Rule 9. So Leonie, do go ahead.
Well, thank you so much. Well, first of all, thank you for organizing these webinars. I think it's really brilliant and it really helps our work. Especially currently we're discussing whether we're going to intervene in a case before the European Court of Human Rights. So it's not the Rule 9 part, but it's the procedure before that. But it really helps these kinds of discussions. So first of all, thank you for organizing all of this. And well, personally, I don't have experience with Rule 9s yet. But I hope someday to have them. But my colleagues do, and it's especially in relation to the Corallo judgment. It was a judgment about the detention situation on Sint Maarten. Sint Maarten is a part of the Kingdom of the Netherlands. So it's not the European part of the Netherlands, but it's the Caribbean part of the Netherlands. Well, there was this individual case. It was said by the European Court of Human Rights. Well, the detention situation in the prison was not in line with the convention. And then, so what did we do in this Rule 9 procedure? Well, we indicated that this individual case was not an individual case. Well, it was an individual case in that sense, but it was a systemic issue at the prison systems in Sint Maarten. And in our contribution and our Rule 9 contribution, we explained what the systemic deficiencies were. We discussed the personal and organizational matters, internal security. So we kind of explained what kind of issues did we notice that were structural and systematic of nature. And in that regard, we also relied on general measures put forward in reports by the CPT, the Law Enforcement Council. That's a council especially aimed at detention circumstances as well, and a progress report from the Committee of Sint Maarten. So we provided evidence to the Committee of Ministers. What we also did is we visited the execution department of the Council of Europe a while ago, and that actually led to the fact that they informed us about this case, this judgment, and the possibility of intervening. So that was really a nice cooperation, I think, between the different departments. And for us, it made it easier internally also to get organized and to say, okay, we're going to intervene. And this part is also relevant at a later stage, to which I will come. But first, what kind of research did we carry out? Well, of course, the desktop research, as I mentioned, we refer to reports. We also had informal talks with representatives of the Law Enforcement Council and other organizations that had a clear knowledge of the situation in Sint Maarten. What we tried to do in our submission was we made this recommendation to the Committee of Ministers to explain that this case, because of the systemic and structural issues that it raised, it should be under an enhanced supervision procedure. And well, that helps. So that actually works out. So that was really great. We did have some problems with the government in the sense that they were not really pleased that we intervened in this case. And that's because of the difficult situation in the Netherlands with the Kingdom of the Netherlands. And our institute doesn't have a mandate to work on Sint Maarten. So the government said, well, you're not allowed to intervene in this case. And so we had to work around that a bit. So in our Rule 9 submission, we also explained that there were some prisoners from Sint Maarten in Dutch detention, so in the European part of the Netherlands, that couldn't be extradited to Sint Maarten because of the poor detention conditions. So we had to work around a bit to get our argument across. And I think that was also probably the reason that the action plan of the Netherlands didn't refer to our intervention, because there were some feelings of us going outside our mandate. But in the end, and I think that's the most important thing, that it is under an enhanced procedure. Probably we expect it to be discussed in the CMDH in 2021. And it's all the more important because in April of this year, there were 3 cases put forward to the European Court of Human Rights relating to exactly the same issue. So there's more evidence that it's still going on, and we're looking forward to what the Committee of Ministers will say about it.
Thank you so much, Leonie. That's a very interesting example. 2 things in particular I wanted to pick up on from what you said. I mean, one is the engagement with the Department for the Execution of Judgments. I think it's worth saying that they're very keen to engage with national human rights institutions at a high level and foster this kind of relationship. So I would encourage anyone else who wants to either have a visit to Strasbourg or encourage a visit to them in their own capital, possibly not right now being the best time, but in the future, I think they are open to that. So I would encourage you to get in touch with them about that. And the second issue I wanted to pick up on was on the subject of enhanced procedure and standard procedure. I mentioned earlier the kind of list of recommendations, which is very important at the end of submissions, and often one that people might miss out on are procedural recommendations. So it's very, people often remember very well, obviously, to put in their substantial recommendations on the topic, the things that need to happen, so legislation or change in practice, but they might forget to make a recommendation to what should happen with the case in terms of procedure. So the most important one I would say is asking for a case under standard procedure to be promoted to enhanced, and that's what has been done in this case, and it successfully meant that the case will now be considered by the Committee of Ministers, which is a really big difference in terms of the intensity of the review.
Exactly.
But there's also other recommendations as well that can be made, asking that the case be continued under enhanced if it's already there, asking that the Committee of Ministers debate the case as soon as possible. Asking for an interim resolution is also another possible option if a case has been subject to Committee of Ministers monitoring for a while and there's no progress rather. So I think that those are all really important things to pick up on from what Leonie said. And I really thank you for that comment. I see also there's a couple of comments in the chat. Gerald has asked for some of the information on some of these cases, and I think my colleague Agnes is sending that information in the chat. She's referred to the Corallo case in Hurok Exec, but perhaps Agnes, you can also send in the National Human Rights Institutions Rule 9, the link to that as well, so that people could perhaps take a look at that if they want to. But Leonie, thank you so much. Was there anything else you wanted to add?
No, it's for us, the last comment you made about the procedural comments that you can make, procedural recommendations, that's really useful. And I think also the other versions of procedural recommendations, that's new to us. So it would be very helpful if we can get this overview of all the options that we have. So it makes it easier for us to pick the right one in the future. So thanks so much.
That's a pleasure. And on the subject of those recommendations, what you can make, I would refer you to the EIN handbook on implementation of judgments. Everything should be set out there in some of the first pages, I think. There's another question, Leonie, from Eleanor Deeming. So I hope you can stay on the line. The question is, could I ask Leonie what the time/capacity commitment was for your team in making the submission?
For me, it's a bit difficult to say because I wasn't working at the Institute at the moment. But I believe that it was, I think our letter is maybe 5 pages long. No, yeah, 4 pages long. So that didn't take that much time to write it out. And because we did already have some information about the situation in Sint Maarten, that wasn't the most time-intensive work. I think it was mainly having contacts externally with the different organizations that took a lot of time, and are also internally. We always have these discussions. We don't have just one head of the institute. We have one head of the institute, but beside that, we have 8 other commissioners who get to decide these issues, whether we are going to act upon something. So I think internally the decision timing took a lot of time, but capacity-wise, I don't think it was that much time because we already had the relevant information and experience with the detention situation.
On the subject of time and capacity and the amount of time it takes, maybe that's something also we can bring in Tamar in on that subject later. But if there's anyone else who would like to come in to help answer that question, do go ahead. I think it'd be really useful for people to know how long it takes NHRIs to write these submissions. So do put that information, if you have experience of that, in the chat. I think that will be a really valuable thing to do. Okay, but for now, thanks, Leonie. Maybe we'll leave it there. And I see I think you're putting your contact details in the chat. That's very welcome if people have other questions. For now, what I think we'll do though is pass over to my colleague Agnes, who's going to continue a bit more of the presentation in regard to the Committee of Ministers process.
Yes. So, hello everyone. I see that Laurent from Belgium also wanted to take the floor. Maybe we'll come back to you later on. We just have to progress. No, that's fine. Okay, great. So I will try to share my screen with you if you give me a second. So, doesn't work.
And maybe I could just say while Agnes is sorting that, Laurent, if you have a question or a comment, maybe you could put it in the chat and then I'll answer it straight after Agnes has given her section of presentation.
Okay, so just put it. Can you see that?
Yes, we can.
Okay, very great. So what I would like to do today, because a lot have been said already about, what you should consider when writing Rule 9, I just want to start again with a very short reminder about the key elements to the process, because when you're writing Rule 9, you have to get the picture clear in your mind, basically, about whether we're talking about a leading case, a case under enhanced supervision or not, because these will affect also the timetable, the timeline of your intervention in front of the Committee of Ministers. So just a very short reminder of what we already touched upon during webinar 2 is where to find the information on your cases. So you have the link here to the UDOC exec website, where you can find basically the status of execution of your case and also all documents which are published in relation to your case. So if it was a case under enhanced supervision, so a case which is monitored by the CMDH, then you will find also the latest CM decision on the case. You can also find there the latest action plan of the government on the case or the action reports. That's important because each time when you make a Rule 9, as we mentioned before, you need to make sure that you add value in a way. So if you want to add value, if it's you would have to react, for instance, to an action plan or to an action report. And in terms of structure, it would be important that you really refer to the latest documents published on the case. Otherwise, there is more or less no point, if you know what I mean. You can also find here the link to the website from the Department of the Execution of Judgments with some further advice about communications by NHRis or NGOs. In terms of timeline, we were mentioning before, or Leonie mentioned before, that the Corallo case might be dealt with into 2021. As you know, the cases under enhanced procedure are put on the agenda of a CMDH meeting. Of course, they are not put each time on the agenda of each CMDH meetings. You have 4 meetings a year. And after each CMDH meeting, you can have an indicative list of cases for the next meeting. So it gives you an idea of whether the case will be on the agenda of your next meeting or not. If it's the case, then it's very important to be aware of that because the delays are normally quite short. And as mentioned by Nikos in his video, it would be important for you to intervene well ahead of this meeting if you want for your comments to be taken into consideration. And what does it mean taken into consideration? It means that if you want to have your submission considered into the notes for the meeting that the department is preparing for the delegates, then basically these submissions should reach the department. Nikos says 5 weeks. We made the experience that 6 weeks before the CMBH meeting is better. If you send it after that, your submission will be made published, as Nikos mentioned, but it won't be included into the notes for the meeting. And it means for the delegates, they might see it, but they won't be able to come back to their government and talk to them about the input of your NGO, and then it won't have such a big impact on the decision of a committee of ministers. So that's something which is important to keep in mind. Here again, the link to your doc exec. Okay, I won't go into details now about how you can add value to your Rule 9. I think George mentioned that already, as well as Nico. So it has to be well constructed, clear, concise, and timely. I will go over these slides now. What I would like to talk to you now about is more the question of the timeline, because in terms of structure, we will have the example of the colleagues from Georgia. So I will send you this presentation after the event in any case, so we'll have enough time to look at our advice. Just let me underline here very shortly that the limitations, let's say, of the Department for Execution of Judgments. They have a relatively small staff. There are about 40 lawyers. Not all of them have expertise in all member states' legal system. Not all of them can also understand the language of all member states. They have limited capacity for country visit, and they are sometimes under the pressure by the member state. So it's sometimes difficult for them also to challenge the claims made by the member states. So be aware of that when you write also your own submissions. Why am I underlining that? Because as said by Leonie, or was mentioned by Leonie, it's important to also keep in touch with DG directly. And Ian can help you on that. We'll come back to that later on, to know exactly which kind of evidence they are looking for. You must imagine, or you must bear in mind that the Department for Execution of Judgments, they receive the action plans from the member states, they receive the action reports, and they have to sort out which kind of information is relevant to them or not, and they rely also very much on your own submissions, on your own feedback to be able to, to react to these claims. So here, I think we mentioned that in our webinar too. This is the timeline for the overall supervision process, and it gives you an idea of when you can intervene. That's the question of timing for your Rule 9.2, which I would like to underline here today specifically. Basically, whether your case is under enhanced procedure or whether it is under the standard procedure, the sooner you can intervene, the better. So soon after the judgment has been final, so it's a new case, you can already make a submission. We had that in the past on some cases, to share with the Department for Execution of Judgments what you think should be the measures taken, the general measures taken to implement a case. I'm focusing here, of course, on the general measures. But you can also intervene once the case has been classified, so under enhanced order standards procedure. And what's important to keep in mind is that you should try to keep regularly informed about where the state of execution is, how far has the case been implemented, has an action plan been updated, updated an action report, and then to try to react soon, right away. And of course, the EN Secretariat can support you in monitoring this process. So here again, some information about when to best intervene. Following the publication of an action plan, for instance, what you can do is in parallel to your Rule 9, what we mentioned here is also to seek the engagement with the government agent or ministries and participate in working group. That's this combination of Strasbourg level advocacy with the national or domestic advocacy that we mentioned in our previous meetings. So here I put again the 6 weeks rule before the CMDH meeting for cases under enhanced procedure. For cases under standard procedure, basically they are reviewed by the Department for Execution of Judgments, but so you don't have these rules because with a CMDH meeting, because they won't be on the agenda of a CMDH, but it's important to also keep informed, let's say, of the progress being made, and we can help us in that. And then, of course, each time when you write a Rule 9, what's important is also to check the status of the execution once you've done the Rule 9. So after the CM decision has been taken, if it's a case under enhanced procedure, see to what extent your recommendations have been reflected, or watch out for states' reply to your Rule 9. Yes, that's what I wanted to say today very quickly, because we'll have a very interesting example of a Rule 9 by our friends from Georgia. So I won't go into more details, but as mentioned, the PowerPoint will be shared with you. So thank you very much. I'll stop sharing my screen. Yes.
Great, thank you so much for that, Agnes. I see a few questions coming in.
Yeah.
So I think that this first one has come in from I think it's Simona, but it's actually for Leonie, and I think Leonie has answered that in the chat. So I think yeah, Simona was asking another important question in regard to this issue of writing submissions. She asked, at what stage did you inform the government and why? If I understand you correctly, your government made some pressure not to make a submission. Did you inform other actors about your intentions? And it would be interesting to see Leonie's response to that. She wasn't quite sure when they made the submission. With other actors, they already had contacts. I just wanted to comment very quickly on that question, actually, because the one downside of making Rule 9 submissions occasionally can be that the governments obviously don't like it when national human rights institutions are putting a different point of view forward to the government in an international arena. So it can sometimes be important to try and smooth over that issue just by making the government aware that you're making the submission, and to explain why you're doing it can sometimes be a valuable thing to do. But in addition to that, was there anyone else who wanted to ask a question to Agnes, or indeed to Leonie, before we move the session on? Okay, Eleanor Deeming has asked, I would like to ask about the possibility of joint Rule 9s. In the UK, we have a relatively complex devolution setup and have 3 NHRIs operating. So in cases against the UK, I think joint submissions might be more impactful. Thanks very much for that question, Eleanor, it's absolutely possible for joint Rule 9s to be made. Indeed, it's very common. We see it happen a lot with NGOs joining forces and putting in joint Rule 9s. So I think that's absolutely possible in the case of the UK, and to write a joint submission there between different national human rights institutions. Aisel has asked the following: how do we avoid the conundrum of the NHRI's communications to committee ministers from appearing as the NHRI's word against the government's word on the subject matter of implementation? In some ways, there's no magic bullet for that, I would say, because ultimately it is one organization's argument against the government's arguments, so it's not possible to completely avoid that. But I do think it's important, as I said, to try and make sure that contact is continued with the relevant government departments before submissions are made, and if possible, also to try and make your points before making the submission straight to the government department, and to say that you're going to engage with the process. It is also a welcome thing to do. We always try and advise our partners in NGOs or indeed national human rights institutions to try and make an input into the process of implementation outside the Strasbourg process, straight to governments before making Rule 9 submissions, if that's possible in the timeline. Okay, so I don't see any other questions having come in for now, but for the moment, I think we'll thank Agnes so much for that presentation, and we'll bring in colleagues from Georgia. So Tamar and Lara, please do come online. I'll be introducing Tamar Abazadze, head of the analytical department at the Georgian Public Defender, and also Lara Jawarauli, chief specialist in international human rights law, also at the analytical department. So welcome, Tamar, first of all.
Hello, good day to all of you.
It's a pleasure to see you, Tamar. Perhaps what you could do is go ahead with your presentation on this case and briefly introduce what the work you've been doing.
So now we are going to present our new communication in the Tsinsabadze group of cases. Let me just briefly explain what is the case about. Tsinsabadze group concerns the failure of the authorities to conduct effective investigations into the alleged violations of the right to life and torture and ill treatment by law enforcement officers. Until now, Public Defender's Office has already submitted 2 communications on this group of cases. The first communication we submitted in 2016, and now the presentation we are going to, the new communication we are going to present before you will be third one. This will be follow-up. This new communication will be follow-up of this process, which we began in 2016. I would like to underline that submitting communications before the Committee of Ministers is a long-lasting process. This is not just one-off event. So it's not enough to submit only one communication concerning the case. And I think that somehow it is important to put pressure on the government in order to achieve result. In addition, it's important to put pressure on the Committee of Ministers as well, in a way to persuade them make our submissions reflected in the Committee of Ministers decisions. So that's very brief. Now I will give floor to my colleague Lara. She will explain how we drafted this new communication, and of course I will be very happy to receive feedback on our draft. Thank you for this possibility.
Hello everyone. I have to apologize because of this technical problem. I will not be able to connect with the camera. Thank you, Tamar, for the introduction, and thanks everyone for this opportunity. I really believe that these sessions will benefit NGOs and NHRIs to engage more effectively in the Committee of Ministers' supervision of execution of judgments. Today, in order to share our experience of drafting Rule 9 submission, I will describe the working process on our recent communication in Tinsa group of cases. First of all, as Tamar noted, this is our third communication with regards to this group of cases, because these cases are revealing structural problems of major importance, and the group is under enhanced supervision procedure. Also, I would note that the Committee of Ministers decided to end the supervision of two other judgments which we are part of this group. And one of them was Garibashvili versus Georgia, which was a leading case in the group. Our Rule 9 submission to the Committee of Ministers is addressing the last government action plan for the Tinsa group of cases, and is bringing to the attention mainly issues that are relating to the general measures. So I think I can share the communication with you now, right? Is it visible?
Yes, we can see that.
Yes, it is.
Okay. So now, sorry. Yes. So this is our communication. This is first page. I will go, this is just to show you the structure, and I will describe the working process. So just to stay on the contents. Okay. So in this case, Committee of Ministers indicated when the case would be re-examined. So we knew ahead that ideally we had to submit the document 6 weeks before the meeting, or not later than 4 weeks. But the question of timing to respond to the state's recent action plan was problematic, in a sense that when we started the drafting process, the last action plan of the government was published in October 2019. And when we were finalizing the document last week, new action plan was published. So we had to go through and identify what additional issues we are to address. And we spotted one more issue of concern and added information on it. So I think it's familiar for most of NHRs and NGOs who are working on Rule 9s, when during drafting ahead of 6 weeks, the government's action plan or report is not published, maybe. As how we put the document together and what were the main sources. As a first step, we looked at the case description. We knew this case, a group of cases, but just to refresh the memory and to look through all the documents published, we looked at the UDOC exec webpage to see recent developments and concerns which DJs thinks that state representatives should be aware of. Then we carefully went through the Committee of Ministers decisions and notes, government's action plans, and NGO communication. As a result of this process, we identified the issues of concern and started to look at the evidence in order to assess whether the measures proposed in government's action plan were sufficient. Generally, we provide information and evidence from our own work and latest reports, as well as relevant information documents issued by the international organizations on the discussed issue. Every source is referred with footnotes. Our main sources for the documents were Annual Parliamentary Report of the Public Defender of Georgia of 2019, Special Report of the National Preventive Mechanism, also from 2019. We also referred to the findings of CPT report, and also we referred to the opinion of Venice Commission of 2018 with regards to the concerns about the reform of prosecutor's office. And of course, we have relevant articles from Constitution of Georgia, Organic Law, Prosecutor's Office, and other legislative bases that we had to discuss. Just to go through the chapters of our communication. So as Tamar said, this group of cases concerns challenges with regards to combating torture and ill treatment. So this chapter we started with welcoming the implemented legislative changes in the process of combating torture in recent years, but then we followed with the concerns that we have in this group of cases. The next chapter, we provided specific information on situation in penitentiary establishments and also ill treatment by police officers. We also referred to the measures regarding the Article 6 violation in one of the cases, which we considered very important to address separately. We will, of course, share with all the participants the communication, so they will have the chance to go through, and if they have additional questions or are interested, we can, of course, provide more information. Also, we mentioned separately the urgent need of reform of the Office of the Prosecutor General of Georgia. And as I already said, in this chapter, we referred to the opinion of the Venice Commission, because public defender shares the opinion expressed by the Venice Commission concerning the role of ensuring transparency of the prosecutor's office and so on and so forth. Most importantly, I think we included recommendations of the public defender of Georgia to the government of Georgia. We compiled the recommendations of the PDO, and we just provided the Committee of Ministers, and we are hoping that these recommendations will be taken into consideration and will be reflected in the decision. So yes, for now, I think I will be glad to answer the questions. Yeah.
That's great. Thank you so much, Lara. I think if you stop sharing your screen, that would be perfect. And thank you so much for that presentation. It was very clear. And I'd also, like to reiterate what I said before, is that submissions from the Georgian Public Defender's Office have always been very, very good, and that's evidenced by that document. You would have seen a few things that we've discussed as being really important. Obviously, the structure being very, very good, the evidence there being referred to in the footnotes of the Georgian Public Defender's reporting, giving us a strong background to what you're trying to say, and also the recommendations, a very clear list at the end as well. One thing that we haven't discussed, which I think you referred to briefly, is there were a couple of times in the document where you referred to the positive steps that the government had taken. You said, for example, that you welcome the fact that the government's national strategy on human rights had highlighted torture as one of the main issues that it wanted to address, and you welcomed the introduction of legislation, while saying that it was in many ways, in some ways, ineffective in practice. And it's really good to welcome the positive developments that have happened as well in submissions. That is useful for the execution of judgments, and it enhances, obviously, the credibility of the organization making submissions. So I see a question from Laurent. Dear Lara and Tamar, what were your thoughts on the possibility to ask for the enhanced procedure on this group of cases? Lara or Tamar, I'm happy for you to answer that question.
If I may,
Go ahead, Lara.
This group of cases is under the enhanced supervision procedure. We didn't take any part in this process. If I understand correctly, Lorraine wants to know what was our role, or how we could contribute to including this group of cases under the enhanced procedure, right? But
I think you're right to spot. I think he was not aware that the case was under enhanced already. So I think that's the clear answer. Is
okay.
that
Yes, then yes, this group of cases are under enhanced supervision.
Yeah. Yes, exactly. We had we were not required to think about this because this is under enhanced procedure already.
I would add that the only additional procedural comments that you could make in such circumstances might be to ask for an interim resolution from the Committee of Ministers, which is a kind of stronger version of a decision. If you want to try and put more pressure on the government to act, and if there's a strong case to be made that the government isn't currently making realistic progress on the case. You can also ask as a procedural issue for the case to be debated more regularly or as soon as possible. And you can also, if the government is asking for the case to be closed or for the case to be downgraded to standard procedure, it is also possible to say, we submit that the case should not be downgraded, it should be kept on enhanced, and of course also that it shouldn't be closed. It's not necessary, or it might not have been appropriate to make any of those calls in this particular case, but I'm just saying those are other procedural comments or procedural recommendations that you can make.
Yes, and maybe to come back to what we said before regarding the timing for Rule 9 submissions, we can also very well make some Rule 9 submissions right after the judgment has been final and before it's been classified. So you will find the cases under UDoc exec, and it's a new case, so it has not been classified. And you can also make the point, as long as it has not been classified, why you would like it to be classified as an enhanced case, because it raises structural and systemic problems, for instance.
I'll just come in again. I think an earlier question was the length of time that it takes to draft Rule 9 submissions. So perhaps Tamar or Lara, you could make a quick comment about that, the amount of time that you dedicated to this particular submission, or in general, how long it takes you.
Actually, in this case, it took us 5 days to draft the communication. As I have already mentioned, we have submitted 2 communications before this communication, and that's why we were familiar with the case. We already knew the main challenges in this group of cases. So it took only 5 days just to draft the new communication, text of the new communication. Unfortunately, it's fact that we have not much time for drafting the communications, and that's why we have only just a week to prepare them.
Thanks so much, Tamar. I think now we're drawing to the close of this series of webinars, but if there are any other questions that want to be asked, now's definitely the time to do it. Another thing I'd like to introduce before I pass over to colleagues from the European Network for National Human Rights Institutions, I'd love it if you could all just fill in a very, very short set of questions that we're going to put up. My colleague Agnes will put a poll, and that will include 4 questions with simple yes/no answers, essentially. So hopefully Agnes can bring up that poll on your screens now, and it'd be really, really helpful for you to just provide answers to these questions, because it will help us understand, whether we can provide more support to you, or indeed how the best way is for us to go forward on this subject, interacting with national human rights institutions. So that would be highly appreciated. As I said, if there's any more questions, do go ahead. One thing maybe I can comment on quickly is questions raised by Laurent about how the Committee of Ministers is deciding things to come onto the enhanced procedure. This question of standard and enhanced, how do cases go onto standard, or how do cases go onto enhanced? It's worth saying that only about 1/4 of cases are under enhanced procedure, and the decision about that is made by the Committee of Ministers itself under the recommendations of the Department for the Execution of Judgments. So they often do it on the strength of the length of time that cases have been pending, but more often it's the perceived seriousness of the violation, I would say, that leads something to be put under enhanced. So that leaves quite a lot of discretion on their behalf to decide where cases end up, and it's really important for national human rights institutions and NGOs to make an input into that. And we often see when local national organizations are making the case for something to be put under enhanced, it does go ahead and be put under enhanced. So I think Nikos commented in previous sessions how important it is to pay attention, not just to the enhanced procedure and the CMDH reviews, but also to the standard procedure. Have a look what cases are pending for your country, and figure out ways in which you can try and prioritize them and get them under enhanced if you think that they're really important and deserve more attention. Okay, so that was the poll. I think now what I'd really like to do is hand back over to Lina Laikas, Chair of the ENNHRI Legal Working Group. Lina, if you're able to come on board, it'd be great to hear your final comments. But for me, I just want to say thank you all so much for participating. For EIN, please everyone just do get in touch with us. My colleague will put in our email addresses into the chat now, and it'll be very interesting to hear from you. Any way that we can help, we're really, really happy to do so. Thank you for your attention. And Lina, I'll hand over to you.
Thank you very much. This was most interesting, the whole series, and today I was very interested in hearing the practical examples that were highlighted. I just do a quick recap on, we had the 4 seminars. I don't know if everybody was participating in all the 4. There was a lot of information which I thought I knew, or maybe I knew but I had forgotten, and new examples and very good experiences. We talked about the importance why the NHRs have to be involved or should be involved. And what I was shocked was that the 43% of the leading cases are still pending. I mean, I looked through the list of my own country, Finland. We have 30 cases, which is a bit of a shocking, but it's mostly due to lack of resources in the ministry. I checked with the government agent and we talked at length about this. 10 of those cases are leading cases. They are all implemented on national level, but there is like all these procedural things that are still pending. But it just goes to show you that even countries that kind of think that they are doing things the right way, they still have pending cases. Then we also talked about this, how the NHRs can participate on national level and on the execution level in the Council of Europe. We talked about the domestic strategies. We talked about how to make the effective submissions today, specifically, and all these practical advices, what to do and what not to do in all these different stages or when conducting the different parts of the procedure, the Committee of Ministers or the execution department. We learned a lot of lessons from different countries, examples, interests, ways to do things that have failed maybe, or not worked as well as they should have, things that have been very good, have had results. So I think it was very well set up. It most certainly, I think for others as well, brought a lot of food for thought. That's how we could do better. I mean, my office hasn't done any of this officially. We are in discussions with the government agent rather regularly on other issues as well. We do a lot of cooperation, but we haven't done anything officially. And it made me think that maybe we should also think of some cases, if there is an issue, we should participate. I was going to talk about a case, but I will leave it because the case proved to be a bit of problematic with the domestic criminal proceedings and all kinds of things connected. So I'll leave that out from here. I want to thank all the organizers, the European Implementation Network, the Council of Europe Execution Department, the ENNHRI Secretariat, of course. They are doing a great job always organizing these and helping us understand better these things and improve the situations nationally. Also the national presenters, I have a list of, at least we had presentations from Slovenia, Armenia, Croatia, Greece, and Georgia. I apologize if something was left out. And I also, just as the last few points, I want to say that this is not the end. I mean, there will be further training, further webinars, further developments, such as the web page for the implementation, so where the NHRIs can find easily instructions or information or guidance on the Rule 9 and good practices maybe from other institutions, and also links to resources and so on. So that will be upcoming. I think it was next year, if not already this year. I'm not sure. Then also all these discussions, they are helping the processes in improving the system of human rights protection in Europe by feeding into the CDDH CISC-5 working group, or drafting group, which met last week or week before, and which is working on the implementation of the judgments and preparing the guidelines for states on the implementation. So the ENNHRI and individual, now I forget, it was Slovenia maybe, or somebody who participated in the previous meeting. So these discussions help to bring NHRI voices and problems and issues also to this platform at the CDDH working group. And then, of course, the further work with the Council of Europe Execution Department and the Implementation Network, European Implementation Network, will help us to improve so we can work on more effectively and learn something more, and the world will be a happier place or something. I don't know, hopefully. So then in the end, I want to thank all the participants with all these discussions. The presentations were very interesting, but the importance is enhanced by the fact that there are participants who are actually asking questions and bringing their own experiences and own problems that they have encountered to the floor. So we can all learn from them and maybe not make the same mistakes, or we can all think, oh, this is also possible. So thank you all for this, and I have nothing further. I'm looking forward for the continuation, and thank you, George, for keeping this all together. And the legal working group is always there if any people who participated want to participate in the meetings, and keep abreast with the developments on these issues and other legal issues in the ENNHRI area. So thank you very much.
Pleasure. Thank you so much, Lina. And I wish you all the very best.